Welcome to Jock Cultures, Cultural Cues, where we have conversations about intellectual property, socially responsible intellectual property, intangible cultural heritage, traditional knowledge, trademarks, and other fun topics. I'd like to welcome Michelle Okyere, who's joining us this afternoon to talk to us about a recent article that she wrote. So Michelle, I'm hopefully I didn't butcher your last name too properly, but
no, you're fine.
And we're so thrilled to have Michelle with us here this afternoon because she has a wealth of knowledge and experience and wrote a very interesting piece relating to cultural appropriation versus cultural appreciation. So Michelle, if you could just tell us a little bit about yourself, and then I'm going to ask you a few questions about the piece that you wrote. Welcome.
Okay. Thank you, Jen. So I am a Ghanaian qualified lawyer currently researching on geographical indications at the Nottingham Law School and under the supervision of Associate Professor Dr. Janice Denoncourt. And before now, I was an associate with Benti Enchil Lecha and Nankuma, a law firm in Ghana. And I was working with the Energy and Infrastructure Practice Group. So awesome. I actually completed my undergraduate in law at the Kwame Nkrumah University of Science and Technology in Kumasi, Ghana in 2015. And then I continued to the Ghana School of Law, where I was called to the bar in 2017. Following this, I completed an LLM in International Trade and Commercial Law at the Nottingham Law School. And I have been doing some work with Dr. Janice Denoncourt on geographical indications protection of Ghana's kente. So I wrote an article with her, and I've presented on several platforms on this. I'm active with the Nottingham IP Research Group as well. So thank you, Jan, for having me.
Oh, well, thank you so much for joining us. So you're an attorney, you're doing research on geographical indications as well in the UK relating to Ghana's kente. And I heard you say that you practice with Benti Enchil, which is, I know, a major law firm in Ghana. So you're a Ghanaian with expertise in geographical indications and as an attorney and as some academic background as well. And so I saw your article titled Appropriation of Culture versus Appreciation of Culture, posted on LinkedIn, and it grabbed my attention because, as you know, I talk about issues around cultural appropriation and cultural intellectual property. In that article, you talked about Jean-Paul Gaultier's use of the birth of Venus. So can you tell us a little bit more about how this becomes a question of cultural appropriation versus cultural appreciation? What is this Gaultier birth of Venus story about, if you could tell the audience? Thank you.
Okay, so before we actually answer how Gaultier's birth of Venus becomes cultural appropriation, let's look at what the difference is between cultural appropriation and cultural appreciation.
Great.
So cultural let's look at appreciation first. So cultural appreciation can be explained as, like understanding or admiring someone's culture, parts of cultural and culture and cultural expressions and values. But cultural appropriation is adopting of culture for commercial gain. Either for money or publicity, without consent or permission of the custodians of such culture. So basically, the main difference between appreciation and appropriation lies in the fact that with appropriation, you require the consent or permission of the owners or the custodians of the culture before you use it for any economic, financial, or profitable gain. But with the appreciation, because no such economic gain is obtained, you don't need such appreciation. You don't need such permission. Right?
Okay. So, in terms of your approach to it, one of the key differences is commercial gain, right? Now, let me just throw in a question for you. Because you talked about the custodians or the owners, and some people might say, well, how do you decide that somebody owns a culture? Like, how do you decide somebody's a custodian or owner, and like who owns, the birth of Venus? How does that come about?
Yeah, so for instance, with the Italian Cultural Code, I know under Article 10, it actually places certain cultural expressions as cultural property. So it says, hang on, let me just find that. Yeah, it says any object with a cultural interest from an artistic, historical, archaeological viewpoint can be declared as cultural property, whether it's owned by a public entity, private entity, or an individual, right?
Wow.
Now, with the, I think under the code, Birth of Venus has been, associated with Uffizi galleries. So basically, Uffizi galleries are the custodians of the Birth of Venus image. So it's out there basically, that's as they are the custodians. And so as the custodians, you would have to request their permission before you use it for any economic gain. Yes,
And
an example.
Oh, sorry, go ahead. Go ahead.
Yeah, another example I would give is under Ghana's copyright law. It says that all cultural property is under the custodianship of the president, basically, for the people of Ghana. So that shows that he's the custodian of such culture. So I guess it depends on every country and who they actually put such rights into, basically.
Okay. But so Italy has under its cultural code that the birth of Venus is part of Italian cultural heritage. Is that right?
Yeah. It's like
okay.
Cultural
So
yeah.
It's part of their cultural property. So can you just talk a little bit more about this? I don't know if people are aware that Jean-Paul Gaultier is a fashion designer, and it seems that fashion houses are the ones that are often getting into these controversies around cultural appropriation.
Yeah.
And so here's another one, but it's involving Italy and it's involving art. So can you just tell us a little bit more about that?
Yeah, so I think that Jean-Paul Gaultier is actually a fashion designer, and what he did was to use the Birth of Venus image as his in his clothing collection. So the issue isn't really that he's using it in the clothing collection, but the fact that he's going to get commercial gain from it, and he didn't actually seek permission from Uffizi galleries before using that, because I know that Uffizi actually approached them or sent a letter of sort and said, if you do want to use it, you need to pay fees for the use. Otherwise, it's going to be considered as cultural appropriation. But they never responded, and that's why they're being sued. Because I know there was another situation where Zara, the brand, actually, they used the Venus image in in their products or something, but they asked for permission from Uffizi. So they have as part of, I'm not sure whether the image online or wherever it is, but it says that with permission from Uffizi or something. Yeah.
Okay. So I mean, basically it sounds like what you're describing is a situation where companies could get into the same kind of trouble they get into with copyright infringement or trademark infringement if they don't check for some of these cultural clearances. Is that fair?
Yeah.
People talk about cultural appropriation, but it sounds like you can actually get sued for this stuff sometimes, right?
Yes, you can. So, like you said, it's sort of a way, and how do you put it? Like an amendment of copyright, if I should put it that way. Because with the Italian code, I know someone would say that if it's cultural property, its copyright has expired a long time ago and it's in the public domain now. But the thing is, with the code, it actually says that because it's cultural property, it gives it protection infinitely. Wow. So so it's copyright, but it's an amended form of copyright. Yes, so that's the same thing with the Ghanaian Copyright Act as well. So it also places, cultural property, it protects it as copyright, but then without any, it doesn't have any, it doesn't have limited protection. So the protection is unlimited,
So, it's interesting because we know that in the intellectual property space, we have harmonization of intellectual property rights, because of the World Trade Organization standards that require everyone to have a certain protection for trademarks and patents and copyrights. And the thing with this cultural intellectual property, like the Italian code or under Ghana's Copyright Act protecting Kente, is we don't have harmonization across countries. So even though there's a risk of being sued, for now, it's maybe not as high as it would be for other types of intellectual property. But from what I see, more countries are protecting their cultural heritage. And I know you wrote a little bit about, in your article, you touched on geographical indications. And why are geographical indications a good way to protect cultural heritage? Can you speak a little bit to that?
Yeah, so
past work on that?
Yeah, so like I was saying, with the Italian code is a version of copyright, and you can actually get sued, because I know under the code as well, it actually talks about the European Union, regulations on cultural heritage. So you can get sued either under those regulations or get sued under the code, and I don't mind, getting sued under copyright. I mean, copyright is good, these cultural heritage regulations and everything, they're good. But in my opinion, I feel like they're not very sufficient to protect it, because, even though we've had these for ages, but people are still appropriating culture, and there's still a lot of issues going out on with these, with appropriation of this culture. So I suggested looking at geographical indications, because more and more countries are now trying to protect their non-agricultural products, including their cultural products, as geographical indications. Geographical indications basically is a sign or a symbol used to link products with their origin. So with geographical indications, the link between the product and the origin can be qualitative, reputational, or any other characteristic link. Now, more and more countries are seeing that with you can actually link a product because of its reputation to a particular country or locality, to that locality. So we have the batik from India, okay, and no, sorry, the batik from Indonesia, and then there's the cashmere from the Kashmir region of India. And these are some of the products that have gotten, cultural heritage protection or geographical indication protection of the cultural heritage. And, they see, for instance, with the Indonesian batik, with the way they make it and everything has been passed from generations to generations. So the knowledge, the traditional knowledge, is actually what is the cultural heritage, basically. The product is also cultural heritage, but they're trying to preserve everything in relation to it. So in terms of the production technique, and also, yes, and then the product as well. So with geographical indications, with using the sign or symbol to link it to the origin, makes it more, it's easier, in my opinion, because with geographical indications as well, you don't need a particular, limited protection for it, unlike the other traditional intellectual property rights like copyright and trademarks and all of that. With geographical indications, it's unlimited protection. And the rights.
You mean in the sense that they last forever, right? The geographical indication is not time limited. They're internationally recognized and protected through the WTO TRIPS agreement. The European Union is big on geographical indications. And so what I hear you saying is that GIs are already established. There's no time limitation. You can protect, connect them to the reputation, the characteristic. Is that fair? And that's
Yes,
another way that
yes,
you can protect
exactly.
cultural heritage. And then that also creates a legal hook, right?
Yeah,
That,
yeah.
like with but is it with the geographical indications, you say it's also about protecting the method, right? So can you talk a little bit more about that? Because it's a name or a symbol. So does the name or symbol attach to the method, but you can use the method if you don't use the name or symbol, or how does that work?
Yeah, so you can't, with geographical indications, when you are protecting it, you have a code of practice that you need to adhere to. So when you're registering the geographical indication, it comes with, setting out the standards, what qualifies as the GI, whether it's how it's produced, where it's produced, what is used to produce it, or whatever it is. It can be a natural factor or a human factor. It doesn't necessarily have to be both. So it doesn't mean that with so if the product is produced in a particular area, it doesn't mean everything in relation to the product must come from that area. As long as there's something specific that is related to, for instance, if it's the reputation that is linked to, or if it's the wood, that is used to produce whatever furniture it is, whatever it is, there should be some form of link, to the product. So that is what is put in the code of practice, and then that's what is used to determine whether a product should have that sign or a symbol as a geographical indication, that particular.
No, this is really fun stuff. It's really interesting because the birth of Venus, it sounds like that was an extension of copyright in some ways. And you've talked about geographical indications, which in US law, we use trademark law certification marks to protect geographical indications. So it's going to be really fun and interesting to see how this area develops. But I think it was great to see your article, because basically you're saying to people, there's cultural appropriation, there's cultural appreciation, but they're also explaining that there is a legal basis, which, as we know, is not as developed yet internationally, but definitely this is an area that, in my opinion, and it sounds like in your opinion as well, people need to be paying attention to.
Yeah.
Is that fair?
Yes, that's correct.
Well, Michelle, thank you so much for sharing your expertise with us. This has been a really interesting conversation for me. I hope you've had fun chatting about this as well. Did you have any last parting thoughts or anything you wanted to share with people that are interested in this topic before we stop?
So I just wanted to say that with geographical indications and cultural appropriation and everything, you don't need to actually protect just the geographical indications in the cultural property. You can combine it with the other intellectual property rights or with the heritage codes or whatever it is. It's just to make sure it's comprehensive, especially because now we don't have an international protection for such cultural heritage. So because of that, you can just, even though Italy has this cultural heritage code, they can actually protect it using geographical indications and get a more comprehensive form of protection for it.
Oh, okay. So you're suggesting having layered IP rights, much the same way that a company, like whether it's Coke or whatever, they'll have their trademark, the copyright, there might be trade secret in there, patent. So you're just talking about having layered rights. I hear you saying, if I'm understanding you correctly, that even though Italy has its cultural code, and that's fine, they could still use geographical indications in addition to whatever is protected under their cultural code to have a more comprehensive
protection
that is also, again, internationally recognized, because geographical indications are part of what countries are required to protect under the international trade agreement, right?
Yeah. Yes.
Okay. So that's really interesting. So you're a big fan of geographical indications.
I am. I am. I'm going to throw it in there every day.
Yeah, so it's not just wine and cheese. We think about geographical indications, we think wine and cheese, which are also part of different cultural aspects, but you're talking about geographical indications as another way to provide more comprehensive protection for cultural heritage. And I guess that's the work you did before on Ghana's Kente, right?
Yes,
Yeah.
exactly.
Well, that's awesome. Food for thought. I don't have wine. I don't have cheese right now. But it's been such a pleasure chatting to you, and hopefully we can continue these conversations on Jock Culture's cultural cues. Thank you so much, Michelle. I appreciate
Thank
it.
you. Thank
Appreciate your
you.
time and expertise.
Thank you.